This is the ERISA Edge, bringing you fast, insightful, actionable advice on fiduciary responsibilities and retirement plans. I'm Don Jones, and our meaningfully different discussion today will focus on the case called Kahn versus Board of Directors of the Pentegra Defined Contribution Plan. Let's give a little background. In this particular plan, going before the federal courts, the plaintiff, which is the plan participants and their beneficiaries, have sued the Pentegra plan, including its board of directors, its investment and management portion of the plan. They had two different trials. One has been completed. One is a jury trial, which is unusual in ERISA. And the jury found Pentegra that they had and gave them $39 million in damages against one of the largest, if not the largest, multiple employer plan in the United States. But the damage isn't over. There's now the judge's portion of the trial. The defense, representing the plan sponsor, have asked the judge not to start the judge portion of the trial, but to give them time to settle. This $39 million in damages is surely going to go up. What did we learn, and what can we do different in our own plans? For those of you listening, some of you may be service providers, a third-party administrator, a record keeper, a trustee, an investment advisor, or for some of you, you may be the actual plan sponsor. Though every case is different, as a discretionary fiduciary, which we are, a full 402A named fiduciary, there's three things that are the cardinal rules in every ERISA plan. Number one, in what is being done by the plan through the service providers or the plan fiduciaries, have they exclusively focused completely on what's best for the plan participants and their beneficiaries? The minute they take their focus off the participant and the beneficiary, they are potentially creating what we call a breach in ERISA. Are they using the highest standards known to the law? That comes under a case called Donovan versus Beerworth. The minute it is not a highest standard, we are creating a breach under ERISA. Did the fiduciaries know or ought to know and use the guidelines of the Common Law of Trusts, which is the restatement of law trusts in its third edition? So to recap, exclusive focus on participant, highest standards known to the law, using the guidelines and the directions of the restatement. I've had conversations with Pentegra in the past. They're very successful, but I knew that they were doing things that a fiduciary should not do in a plan. I want to take you through 4 warning signs. I want your barometer, your North Star, to be, was it highest standard? Was it for the good of the participant and their beneficiary? And did they use the Common Law of Trust or the restatement? Warning sign number 1. In the Pentegra plan, they were the judge and jury. They were the 316 fiduciary. What does that mean? Well, they could have had an independent 316. Why did they remain their own 316? Well, there's 2 reasons, pretty likely reasons. And I want to take you back to the very beginning of ERISA, 51 years ago nearly. I've said many times ERISA was created out of a crisis, that of Studebaker, the car company. And Studebaker was its only judge. And though they didn't have names like they do today for fiduciaries, they were the only one looking over the plan. In the Pentegra plan, they were their own 316. That is administrative functions. Remember that. We're going to go over that later. Now, they could have delegated that responsibility, if they weren't afraid of someone else looking over their shoulder, to what under ISO is called ISO 9000, a second audit or a second review. One of the very first things that ERISA did is require that as a plan got larger, it required that there must be the delegation of who's looking at the finances to a CPA financial auditor. But ISO 9000 can be used in all parts of the plan so that you're not looking at your own work. So danger number 1, and if you are a plan sponsor or a service provider, no matter what people say, if they're auditing their own work or reviewing their own work, buyer beware. Warning number 2. This comes under what we call ERISA 408B2. It is a breach. It's called a prohibitive transaction for any service provider, and I want you to be thinking the role you're in, to be paid out of plan assets. It's automatically a breach unless the fees being collected by the service provider is clearly transparent and there's a test done by the responsible fiduciary to make sure the fees are reasonable. Pentegra, as its own judge and jury, either didn't run the 408B2 every year because plan costs change, to be transparent, and whether it's reasonable. So because of not having an independent discretionary fiduciary, they either didn't do it or they did it and chose to be what's called in the law ignorant of what they are doing, chose to ignore it in what they're doing. Warning number 3, though it doesn't take a big part of this plan, but it is hinted at that the core funds were very expensive, and many were, I've seen it, were very expensive, the core funds, and they did not meet what is called a cost efficient or cost conscious standard. In other words, they were not aware of or chose not to do, under again the restatement, section 100B, using a comparator that is in the best benefit of the participant, not a service provider. To put it in plain language, if you're a service provider, no matter how it's fun, no matter how much someone says they love you and they're taking care of you, and they're using a suitability standard, most likely they do not know or don't care to know the restatement 100B. Third warning, not using a proper comparison for the core funds. Fourth warning, and perhaps this is the most damning. In a white paper, Pentegra actually said, and I'm going to read this, if in doing your review you agree with this, you should not use our services. I've paraphrased the last part of it. People have often asked us, why don't we do just 316 alone? Well, because there's not enough to do. The competent TPA has already done it. Yes, we could sign the 5500, which we do, but it wouldn't cost much to do it. Pentegra had a hefty fee for this. And 402 duties are not the same as 316. So they really only did 316, which is called a directed fiduciary, meaning they were going to do the work, but in the end, the responsible party was not them. So let's review 4 warning signs that you should see in the Pentegra plan, in my opinion. And if any one of those are being done in one of your plans, whether they're an individual plan, a MEP plan like this, a PEP plan, a DC group of plans, what are the cardinal rules? Exclusively focus on the participant. Did Pentegra do that? No, not in all cases. Did they use highest standards known to the law? Apparently not. Did they understand and or use the restatement? Apparently not. What we want you to be aware of is Pentegra is not an unusual case. It is the norm. It is being done all the time. If you are aware of any one of those 4 things not being done in your plan and you're a service provider, call us. We are always an independent, discretionary ERISA 402 named fiduciary. We are meaningfully different. Thanks for watching the ERISA Edge. If you found this helpful, be sure to follow Fiduciary Wise for more insights on fiduciary responsibilities and retirement plans. And stay tuned for our next video.